This is Carissa Murphy and Katie Enright with Juris Dictum.
Here is part 1 of our interview with Associate Dean Wesley Oliver.
Hi, Professor. How are you?
I'm fine.
Can you tell us about your time in practice prior to your teaching?
Yeah. My clerkship was with the Tennessee Court of Criminal Appeals in Memphis, and my first job was at a solo practitioner's office in Nashville, and he ran a really high volume practice. So every criminal defense lawyer reaches a point in their career when they become kind of famous, and they either take on a whole lot of cases or they raise their fees. He took on a whole lot of cases. We had a docket or a list of clients that we would have gladly traded with the public defender. And that's how many cases this firm represented, and it was wearing me out. I would drive from town to town all over Middle Tennessee primarily, but all over Tennessee, sometimes Kentucky and Alabama even, representing these clients. Most often you'd plead the cases out because you couldn't take nearly all the cases to trial. And even then it wouldn't have been smart, even if you could have, because most cases do and should plead. But after about 8 months of answering the docket for this guy, who was fairly famous, we had a really large caseload, I got an offer to go with a small firm that was then located on Music Row, and we did primarily federal criminal work, some state stuff, primarily drug cases. So I kind of developed an expertise in search and seizure law, and did pretty well at that. And when I left to try to pursue an academic career, I kind of developed an expertise in traffic stops. And roughly half of all the clients I represented in these drug cases that had traffic stops were either acquitted or had their cases dismissed. So that was kind of what led me into academia in a couple of ways.
Was there one case when you were in practice that you found particularly interesting or that made a lasting impression on you?
Oh, yeah. I represented a guy named Adam Colsey. And Adam Colsey had been convicted, or he had been charged with possession of 5 pounds of marijuana in the back of his car. He was an African-American man, reasonably well-dressed, in his mid-30s or so when he was stopped. And they chose to arrest him for speeding. And when they arrested him for speeding, they found the 5 pounds of marijuana in the trunk. There was nothing about this guy that would have suggested that you could find drugs on him if you searched the car. So it looked like a classic case of profiling, which at the time I represented him really was kind of the big hot ticket issue in criminal law. Driving while black was a term that came into being at that point. And so I represented Adam, and we won his case in the Tennessee Court of Criminal Appeals. Within a week of us winning that case, the U.S. Court of Appeals for the Fifth Circuit decided Atwater versus La Vista and held that the Fourth Amendment does not limit an officer's power to arrest a person for even a minor traffic offense. So I had just won the same issue in Tennessee with Adam Colsey, that the Fifth Circuit rules the opposite way in Atwater versus City of La Vista. And so I contacted the attorneys and I said, I want to help you out. I want to take the case to the Supreme Court with you. I think we could probably get this case in. They said, well, we've looked at it and we don't think we should try because we don't think it'd be worth the client's money. I said, oh, the court will take this issue. And this was the arrogance of a 29-year-old. The court will take this issue. I guarantee you they will. And certiorari is like what, a 1 in 10,000 shot or a 110,000 shot. So this was like the stupidest thing I could have possibly said because, you can't predict something like the court accepting certiorari, but I was right. And they did take it. And then we ended up losing 5-4 in the U.S. Supreme Court. So Colsey's case plus the Atwater case that it sort of became a part of, and the Colsey case became part of the conflict of law that led the U.S. Supreme Court to take the case.
So you touched on it a little bit, but what specifically made you want to go into teaching?
Well, I had a couple of undergraduate teachers who really inspired me, and I really think I wanted to be those people. I had a professor who was just this amazing guy. He was quite the performer. He taught us political theory. And so he would get so enraptured with his presentation that sometimes he would forget he wasn't on a stage and that he was in a lecture hall. And he would get applause regularly at the end of a class. And he got a standing ovation at the end. And I wanted to be that guy. And then there was another professor I had for legal history. His name was Charles McCurdy. And I had been a science major up until the time I took this legal history class. All the chemistry, physics teachers I had, I thought, those are really smart people, and I could be that smart if I tried. When I took Charles McCurdy's class for legal history, I watched him and I thought, I could never be that smart, and I want to be. So between these two teachers, I developed not just an interest in law, but an interest in doing what they had done.
What brought you to Duquesne?
I was teaching at Widener, and I was trying to do a lot of things in addition to just traditional teaching and publishing. I had a TV show on the Pennsylvania Cable Network. I had just begun doing a little bit of work with NBC News. And the environment at my previous law school was not as accepting of that type of high-profile activity as I would have liked. And so they were looking for someone here who was very, very senior in criminal law, who would kind of define the program. And so they were actually looking at much older people than me who had much longer track records than I had. In my work with NBC News on the Sandusky case and some of the other projects I'd worked on made them give me a look. My sense was when they were trying to recruit me that they would be more comfortable with the kind of wide range of things that I wanted to do in the school where I previously taught.
So how has your experience at Duquesne compared to your other teaching experiences?
Yeah. I of course, taught at a lot of places, only one other in a standard doctrinal mold. But I would say that it's not that different. So you would think there would be this huge gap between a Harvard law student and a Duquesne student. You just think that would be true. And there's not. There are probably fewer people here who are rock stars than there are there. In fact, not probably, there are. And I know that's going to sound bad, but that's just true. But there are rock stars here. And what's interesting is I don't think the difference between what makes a greater percentage of those folks great law students has anything to do with LSAT or GPA. I think that the things that make law students, the rock stars, are how much they actually care about it. And there are, a number of people here who really, really care. And those people could compete with anybody. Anybody. I don't care what your LSAT was. I don't care what your GPA was. I don't care where you went to law school. Do you care about it? Do you dig in? Do you listen to positions that are contrary to your own? And do you try to figure out why things are complicated? When I was teaching at Widener, there was a student who came up to me just really frustrated after class. And he says, we don't like how hard you're pushing us. We understand that you did this teaching fellowship at Harvard, and we want to know how you're teaching the class differently here than you teach it at Harvard. And I said, I'm not. And he says, what are you thinking? How do you think we were able to do what you were demanding of them? And I said, well, what do you think you're going to do when you walk into court one day and look across the table and see that your opponent went to law school in Cambridge, Massachusetts? Do you pack up the tents and go home? Do you say to your client, my God, he went to a better law school than I did. I can't do this. You've got to compete with anybody and everybody. And so, no, I've never thought that one should teach any differently or have any different expectations at one place or the other.
Thank you for tuning in. Check in next week for part 2.